May I have my lord kind leave to mention a matter, my lord. This is, my lord, this is actually, my lord, the matter appearing before the Honorable Justice J. Sengupta, my lord, and being item number 2218. The matter was mentioned on several occasions, and last occasion, my lord, his lordship said that he can't upgrade any matter because of the coming puja vacation, my lord. And my lord, this
So it
is
running is item number
2218
Appellate side,
of the
their
appellate,
appellate.
monthly appellate side list, my lord, combined list of August.
Yoshimita. Some of them. This is a criminal revision.
Criminal revision. And my lord, this is actually a crime against the my lord omen. My lord, there is certain urgencies, my lord. The matter was taken up before the vacation bench in the month of May, and the copy has already been served upon the accused persons, my lord. There is some certain expedition is required, my lord, in this matter.
You give the letter, let us see.
My lord, I have appeal for an already consumer bench has refused to, that has been rejected after 4 years of hearing. And so finally, I have appealed for a FAT on division bench. But my lord, Honorable Justice Sabyasachi Bhattacharya said that he will not hurt the consumer matter. So I am seeking for your help so that a suitable bench can be assigned, my lord.
Why that bench doesn't have determination?
No, that bench has the determination of FAT only. That's why I mentioned through video conferencing while I was in Delhi, but he said that I will not hurt.
Unless it is released, how I can pull out the matter?
My lord, at least keep him, his lordship and.
Let us verify. Just take the letter and give it.
May I have my lord's another
Thank you, my lord.
It's a tender matter, my lord. It was taken up by the Honorable Justice Parthasarathi Chatterjee, my lord. It's a 2025 matter. His lordship is when his lordship was taken up before the vacation bench, my lord. And my lord, this matter cannot be included, my lord Justice Amrita Sinha's list, my lord. Although her ladyship has the determination over the matter, my lord.
Why?
Because of my lord, the pressure over the court, my lord.
What to do?
My lord, if this can be taken up, my lord, because this is hard in part, my lord, if this can be assigned before the Honorable Justice Parthasarathi Chatterjee, my lord.
You give a letter tomorrow to the OSD.
Very good, my lord.
My lord, I have only humble prayer, my lord. Yesterday I mentioned one matter 148 proceedings, my lord. Proceeding is on, my lord. So I have come before your lordship against the refusal of the stay of the single judge. My lord, kindly take up the matter because your lordship allowed me.
Monday.
Grateful. This is the matter. Grateful matter.
Sir, daily list item number 1.
What is the correction?
Lordship, I am being
number.
told that the GA number, there is only GA1. It has been wrongly typed as GA2.
There was only one G.
Yes.
Correct it.
Item number 2.
Filing the written notes of argument.
You have already filed it.
Lordship.
They have filed earlier. We'll receive it. There's some clarification we want.
My lord.
Lordship.
Next week we list the matter once again. Under the caption, what caption you will put?
To be mentioned.
For direction or something.
Lordship, can it be?
Written notes of submission filed by the appellant revenue is taken on record. Let the matter be listed next week under the caption for direction.
Lordship, may I?
Not direction or for further hearing. For further hearing.
Lordship.
I went through the papers. Some clarification is there. I'm not able to recollect.
Lordship, can it be kept on Wednesday? Lordship, I will be traveling on Monday, Tuesday.
Wednesday
27th?
Difficulty for me. Wednesday, according to
Wednesday, Thursday, Lordship. Friday.
Or the following week.
Monday is not convenient.
Lordship, I am Lordship traveling Monday, Tuesday, Lordship. Only 2 days.
Then we'll have it on 2nd September.
2nd September.
Lordship. Lordship.
My lord, Lordship, may I kindly see our notes of argument? My lord, I have segregated all the facts. It will be helpful for your lordship.
Yes.
If there is any.
We'll go through it.
Copy may be given to me.
Copy.
You give one copy.
I will share. Soft copy.
কপি দিলে হবে
You do one thing,
হ্যাঁ দিয়ে
you circulate the set along.
আজকের মধ্যে দিয়ে দেবো আজকের মধ্যে পাঠাবো
না পেলে একবার হোয়াটসঅ্যাপে রিমাইন্ডার
Application tax
Right,
matter
also.
আপনি
How many days delay?
764.
They followed the assessee's own case,
My lords, for assessment year 2013-14.
13-14.
But the other aspect notice that the question which has been formulated, that the amount is at page 5 note of the application. They're challenging the transfer pricing adjustment of 5 crore 75 lakhs. But the tax effect on that works out to less than 2 crore. It's about 1 crore 77 odd lakhs. And they mention in paragraph 15 that it's 2 crore 96.
That is wrong.
That is, so it is less than 2. And the other thing is that they have mentioned in the memorandum of appeal that the case for assessment at 1011 is pending. But 1011, the copy available with the assessee, there the issue is regarding royalty, whether it's capital or revenue. That was it arose out of revision proceedings under section 263. So this transfer pricing is not a question there. So I do not know which appeal they are referring to as pending before this honorable court. I have the order of admission in the other matter.
That is not a question formulated. Now, the discussion starts from the first issue, or which are the issues which are covered by the order for 13-14.
13-14
first issue my lord the first
transfer
issue,
pricing adjustment.
transfer pricing adjustment that issue.
So that is covered. That order has not been challenged.
That they have, there's no service on the assessee of any appeal.
Then at page 54, para 10, once again the tribunal says coordinate bench assessee's own case for 10-11, 11-12, 12-13.
This is the royalty question note which is before my lords in 10-11. But this arose out of 263 proceedings. So therefore, this that will be an aspect which my lords will require to consider whether the 263 at all lay or not.
But apart from that, 11, 12, 12, 13 is also there.
But 11, 12, 12, 13, the tribunal decided in the assessee's favor. The revenue did not come up on royalty.
So 10, 11 question admitted was something different.
Yes, but different from what is formulated here.
11, 12, 12, 13 has become final.
On royalty, it has become final, but that is not the question here.
Delay is huge, sir. All right, please come, sir. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961, within bracket the act, is directed against the order dated January 4, 2023, passed by the Income Tax Appellate Tribunal C Bench, Calcutta, within bracket tribunal, in ITA number 2084/K1/2018 for the assessment year 2014-15. We have heard so and so. There is a delay of 764 days in filing the appeal. We have perused the petition filed for condemnation of delay, and we find that the condemnation of delay, full stop. The impugned order was passed by the learned tribunal on 4/1/2023, copy of which was received by the appellant department on 1/2/2023. The appeal ought to have been filed um,
31st of
on
May
or before 31/5/2023, but has been filed on 4/7/2025, and in this process there is a delay of 884 days. After deducting the 120 days time granted under the statute for filing the appeal, the delay is 764 days. We find that the reasons to be absolutely vague and not satisfactory, so as to exercise any discretion in favor of the appellant department for condemnation of inordinate delay of 764 days. Apart from that, we have perused the order passed, impugned order, and we find that the tribunal has followed the earlier decision in the assessee's own case for the assessment year 2013-14. And in respect to another issue also, the learned tribunal has followed the decision of the tribunal in the assessee's case, assessee's own case for the assessment year 2010-11, 2011-12, and 2012-13. Though it is pointed out by the learned standing counsel for the appellant department that so far as the order passed by the tribunal for the assessment year 2010-11 has been challenged before this court in IT 386 of 2017. The question of law which was formulated by the Honorable Division Bench by order dated 19th July 2018 is different from the question which has been formulated in this appeal. Thus, for the above reasons, we are not inclined to exercise any discretion in favor of the appellant department, and therefore the application paying for condemnation of the delay in filing the appeal GA1 of 2025 is dismissed. Consequently, the appeal stands rejected. So one more, it is pointed out by the learned senior advocate appearing for the respondent assessee that the revenue cannot pursue this appeal on the ground of monetary limit, since the tax effect involved in this appeal is less than rupees 2 crores. 2 crores, and it has been wrongly mentioned in paragraph 15 of the memorandum that the tax effect is about rupees 2.96 crores that you just record. I'm great.
Item number 4.
Wait, please, Your Lordship.
You have they've received.
There's a delay of 40 days in preparing this appeal.
That is no problem.
Oh, fine. Fine. Yes,
Mr. Miraj Tisha has appeared before the tribunal. Prothush.
based on the ponderance of probability that was a tribunal.
But the fact that this assessee traded in the shares of Appu Marketing,
Yes.
that was already on record.
No, but
When they completed the assessment under 143 initially, that was already on record.
that is my lord, the finding of the tribunal, wherein my lord, tribunal had found that the reopening was bad in law. But my lord, this is a my lord penny stock company, and my lord bogus long-term capital
Correct.
gain has
But
kept.
then, if it had not been disclosed in the original return,
Well.
then it would be fresh information. Then based on that, you will have to make some inquiry and say that there is tangible material, therefore this particular thing is bogus. That is why the tribunal says that, what is the tax effect?
Tax effect is
Tax effect is 5 lakhs.
5 lakhs. And this falls under the exception.
Exemption, correct.
5 lakhs.
And how many cases? Two cases.
Three cases. But see, assessment here of the same assessee.
Please come. This appeal filed by the revenue under section 260 capital of the Income Tax Act 1961. Within bracket, the act is directed against the order dated December 30, 2024. Passed by the Income Tax Appellate Tribunal A Bench, Kolkata, within bracket tribunal. The ITA number 190 190/K1/2024 for the assessment year 2015-16. The revenue, there is a delay of 40 days in filing the application. The respondent has been served, but none appears for the respondent. As the delay has been properly explained, the same is condoned. Application in GA number 1 of 2025 is allowed. Para. We have heard Mr. Tilak Mukru also. The substantial question of law suggested by the revenue are as hereunder. Page 4 and 5, A and B, C and D not required. The assessee preferred the appeal before the tribunal challenging the order passed by the National Faceless Appeal Center within bracket NFAC under section 250 of the Act. The question which fell for consideration before the learned tribunal was whether the assessment, the reopening of the assessment under section 147/148 of the Act was valid in law. The learned tribunal has examined the factual aspects in a very detailed manner and found that the action of the assessing officer was not valid for the purpose of reopening of the assessment, since the reason stated for reopening was that the assessee had traded in shares of Appu Marketing and Manufacturing Limited EJECTA Marketing Limited, which information the learned tribunal found was very much available on the record when the assessment was completed under section 143 within bracket 3 of the Act. Therefore, we are of the view that the learned tribunal was fully justified that there was no reason to believe that income chargeable to tax has escaped assessment, and that the assessee failed to fully and truly disclose all information for completing the assessment. Thus, the conclusion of the tribunal that the reasons assigned by the assessing officer for reopening the assessment are not reason to believe, but reason to suspect is well founded. Thus, we find there is no question of law, much less substantial question of law arising for consideration in this appeal. Accordingly, appeal feels dismissed. So, 3 separate orders that assessment is. In all cases, 40 days delay.
Yes, yes.
So 3 separate orders.
I'm grateful. Two, three separate orders.
Great.
I'm grateful.
Number 7.
And for the applicant, my lord. My lord, the application is for condonation of delay,
How many days?
121 days, my lord.
Respondent served.
My lord, the respondent could not be served, was returned back, my lord. My lord, the reasons for delay are laid down in paragraph number 3 and then
No,
consecutively.
somebody can accept notice. Both of you. We'll condone the delay today. Yeah, have you got one extra set of
Yes,
papers?
yes, I'll serve here.
We have heard the learned advocate appearing for the appellant assessing. There is a delay of 121 days in filing the appeal. It appears that the department has been served, but as on date, no standing counsel has been nominated to appear on behalf of the department. Therefore, we have directed Mr. Tilak Mitro and Mr. Prutu Dorial and senior standing counsel to accept notice on behalf of the department, and their appearance shall be regularized by the department and their fee bills be honored. Full stop. The
120.
we have perused the affidavit filed in support of GA 1 of 2025, wherein prayer has been made to condone the delay of 121 days of filing the appeal. As the explanation given is found to be satisfactory, acceptable. The delay in filing the appeal is condoned. GA 1 of 2025.
CIT judicial. Get.
Extremely grateful.
Number 8.
We are appealing with this. 185 days. So,
For the appellant. There is a delay of 285 days.
so,
Yet the SSC had filed there was a search and seizure operation which was carried out in February 2017. Thereafter, in October 2017, the SSC filed the return showing the income as nil. In the
What happened to the notice? Served, not served?
it was served.
Served.
They received.
But if you can inform Prithvish,
Yes, I'll from a Lordship will fix out.
we will condone the delay today,
Yes,
so that on next hearing he can appear.
yes, yes.
We have heard so and so, so and so. There's a delay of 285 days in filing the appeal. The respondent has been served and affidavit of service has been filed, but none appears for the respondent. As the explanation offered for the delay in filing the appeal is found to be satisfactory and acceptable, the delay is condoned. Application in GA number so 1 of 2025 is allowed.
deeply well.
Number 9.
My lord, service is not complete, my lord. We had served, we had sent it by post.
List after service of notice on the
Well,
respondent.
kindly give us liberty to serve again because we have again.
All right. The notice sent by the department to the respondent has not been served. Fresh notice to the respondent.
Well, a list after service.
Pardon?
Matter to be listed after service. We will mention it. Otherwise,
To be listed after.
grateful.
Number 10.
Malada, I need a week's time to complete the service.
All right. List after completion of service of notice on the respondent.
I'm deputy.
Number 11.
11.
I'm bole to, sir.
Bolo to.
Well, in item number 11, the learned advocate will appear before the learned tribunal. I have informed him, and some Bhaskar Sengupta will accept the service today. I am informed that, my lord.
And for the state, my lord.
State.
The state to know. 11. Interpol.
You please give the case.
Today will say, my lord, I have also talked with Mr. Bhaskar
Notice has
Sengupta.
been served.
Yes, my lord. They will accept the notice. Mr. Bhaskar Sengupta will accept the notice on behalf of the respondent, my lord.
Nobody is appearing for
Nobody will appear. He was present, but
No
No.
problem. So we'll record his.
yes, my lord. Yeah, record.
We have heard so and so, so and so. Delay of 160.
My lord, one indulgence, my lord. They said that not to condone the delay today because
They have not got that in instruction.
just they will appear, my lord.
All right. List next week. So let's say people are ready. No.
2nd September.
All right. 12 to 15. Let us see.
2nd September.
এই নামটা
Item number 12.
My lord, I am appearing for the respondent authority.
Even last occasion, nobody appeared.
Yes, my lord. Last occasion, nobody appeared. Your lordship was directed to file them to appeal memorandum filed before the tribunal in last occasion. My lord, thereafter, they have not come. My lord, last occasion matter also adjourned. This is a my lord, case of my lord, section addition under section 68. And my lord, here is a my lord,
All right. None appears for the appellant. So and so for the respondent. September. Give a date.
next is also my lord, same.
Item 12 and 13 same.
Item number 14. Number 15.
We have the respondent.
My lord, in this matter, I'm led by Mr. Obro Majumdar. He's not present today. I'm praying for not today, my lord.
At the request of the learned advocate.
There is no delay.
Please stop, please. We'll take up the appellate side matters now.
Okay.
Grateful, your lordship.
Item number 16, but if I may just point out, that on the last date, your lordship had directed that sector 17 of 2005 will have to be tagged with this matter, Miller, and a copy of that may be served on us. But that matter is not appearing in the list even now. It's only
All right.
this appeal that is.
All right. List is so and so along with this appeal. Let copy of the appeal papers be served on the learned advocate appearing for the respondent assessee.
My lord, after 2 weeks.
Appeal and the restoration application.
Appeal and the restoration.
After 2 weeks. We appeal number to be.
Time नहीं तो sir, it had to time na wo yes.
And the
Appellate side, daily list. Item number 1.
my lord.
Time na wait. Time na wo. Time नहीं तो दे सर
Well, may I request my lord, item 15 to be taken in some priority, my lord. I have already my lord, given them the advance notice. Item 15, my lord.
Yes.
Not today, but we'll make a note.
And if it reaches, my lord, then not make it not today, my lord. If it reaches
Today, my lord.
in case, my lord, if your lordship is not giving,
That is, it won't reach today, but we won't, it will remain in the list. We'll give some priority next week.
next week.
My lord, in item number 1, my lord, Mr. Dey is appearing, my lord, due to some personal medical issue today, my lord, he is unable to come. And my lord is directed to take instruction, my lord. He will argue in this matter. We have also taken instruction, my lord. We will argue in this matter, my lord. That the flower mills matter, my lord. We will argue, my lord, next time.
At the request of the learned advocate for the respondent department.
Kindly keep it next Tuesday, my lord.
Next Tuesday, next. Grateful, my lord.
Next Tuesday.
Number 2, my lord.
Lordship, I am for the petitioner. Lordships,
Ducking. This is the application. Two.
But you could have sought for cancellation of this order. There is a provision. No? You can file an application.
Lordships, what has happened, the reason given for the cancellation of GST registration, that has to be followed through a proper procedure. Rule 25 prescribes the proper procedure. That procedure has not been followed at all. It specifies for a mandatory presence of the particular person in whose name the registration has been given. That notice was not served upon us. The physical verification, if at all done, the documents for that had to be uploaded in REG 30. That has not been done. In the impugned show cause notice.
Where is your reply to the show cause notice?
Lordships, the reply was not there because when the show cause notice was issued, even then it had to be suspended, but my registration was not suspended. I was able to file my returns. I had no knowledge that the show cause notice has been issued, and I was filing my returns. Subsequently, when I could not file my returns, then only I got to know that an order has been passed for cancelling my registration. And against that, I have come up in the writ petition that it had to be followed.
Under the Act, there is a provision to seek for revocation of this
Absolutely, Your Lordships. But Your Lordships, what has happened, even if I seek for a revocation of my cancellation.
Establish that you are carrying on business. That you need to establish. That's all.
Your Lordships, I can establish my what has happened in Rule 21. It specifies that the declared place of business has to be verified. What they have done, they have just gone to my principal place of business. If at all they have gone, they have not given me any evidence that they have gone at all. But they have not taken any.
See, the problem is, whatever your submission, that was never placed before the department. That is the problem. If you would have sought for revocation with all those details, yet they have rejected your revocation application, probably without filing an appeal, you could have come to this court. Or with the best option is, you treat this order of cancellation at page 54 as a show cause notice. You raise all the points. We will direct them to reconsider.
Lordships, may kindly give a very short period of time because my registration.
You give your reply within a week. Thereafter, they'll fix a date for personal hearing. Within a week thereafter, within 2 weeks, they will decide.
Deeply obliged.
Grateful.
The intra-court appeal by the writ petitioner is directed against the order dated 25/6/2025, by which the writ petition in WPA 10811 of 2025 filed by the appellant was dismissed. The order impugned in the writ petition is an order of cancellation of registration granted in favor of the appellant under the provisions of the GST Act. According to the appellant, no notice was served, and there is also, and the procedure stipulated under Rule 25 of the GST rules have not been complied with. As against an order of cancellation of registration, the statute provides for a remedy to the assessee by seeking for a revocation of the order of cancellation. If in the event of rejection of the revocation application, appellate remedy has also been provided. The appellant has not exhausted such remedy. However, considering the facts which have been pleaded in the writ petition and as well as in this appeal, we dispose of this appeal with the following direction. The appellant is directed to treat the order of cancellation of registration dated 10th of February 2025 as a show cause notice and submit their reply to the same within a period of 1 week from the date of receipt of the server copy of this order. On receipt of the reply, the authority, namely, who is the authority? Superintendent, is it? The authority concerned shall fix a date for personal hearing within a week thereafter, and thereafter, after hearing, and after hearing the appellant or his authorized representative, fresh orders be passed on merits and in accordance with law within 10 days from the date on which the personal hearing is concluded. The appellant is at liberty to canvass all grounds before the concerned authority. Great. Next.
Serial number 3.
Three, my lord, not today, my lord. 3, 4, 5 all not today.
Lordship, Mr. Kondalia appears with KK Mehti in item 3 and with Topon Bonjo in item 5.
You have heard so and so, so and so.
Serial number 6.
Lordship, I am for the petition.
What is this?
Lordship, here my appeal was under GST Act was rejected only on the ground that there was delay in filing the appeal. Lordships, there is a substantial amount of delay of 333 days. But Lordships, what has happened in the original adjudication order, that order was passed without granting me any personal hearing, and that is evident from the show cause notice itself, wherein no date was given for personal hearing. And subsequently in the order also, it has been mentioned that only a date for reply was given, no hearing was given to the petitioners. Your Lordship, that is the only thing. I have never been allowed to make any submissions on merits. Your Lordships may kindly give me one opportunity just to.
Where is the show cause notice?
Lordships, page 51 to 57. Lordships may kindly come to page 52. The small table details of personal hearing, etc. The date by which reply has to be submitted has been given, but date of personal hearing is NA, time of personal hearing is NA, and the venue where personal hearing will be filed is NA.
What was the allegation in the show cause notice? They would have an annexure to this. No?
Your Lordship, there is annexure page 41. Lordships, the allegations start from DRC 01A, the intimations. Page 41 is the accurate.
And what was your reply?
No reply was filed.
Your Lordship, reply was not filed.
Reply was not filed.
It is actually, they've said some discrepancy is there. This is not a show cause notice.
Lordships, no. Subsequent to that, page 52 is the show cause notice.
A detailed show cause notice.
Page 56 is the detailed
show cause notice.
The total tax liability is 21,81,000.
Yes, Your Lordships.
173.
Yes, Your Lordships. Yes, Your Lordship.
Then what happened to the revision before the senior joint commissioner?
Lordships,
Appellate authority.
appellate authority was what
appellate
happened.
authority.
We filed an appeal. In the appeal, we received a show cause notice.
63 days.
Page 81.
363 days is after 3 months. But considering the 1 month period as the condonable period, 333 days has been calculated, Lordships.
And where is the order passed by the appellate authority?
Page 81, Your Lordship.
Page 81, Your Lordships.
But if it is beyond the condonable period, he can't exercise.
You see, Lordships, it is there, but Lordships, if your Lordships may kindly come to page 72, that is the actual ground. It is a very small case, Lordships. What has happened in the electronic portal, my imports are not generated. Even though I have all the bills of entries and every document substantiating that there were imports, but in the IceGate portal, the imports are not showing. On that basis, my ITC has been disallowed. And there is no other point. That 20 lakhs, odd lakhs is absolutely on this point itself, nothing more. Lordships, I have to just show the documentary evidence that there are certain imports which have to be taken into consideration. Apart from that, no grounds are there. Lordships, one more opportunity would.
We'll put you on some terms.
Absolutely, Lordships, I can understand, Lordships.
So the total tax liability is 21 lakhs. Where did I see that? Adjudication order.
Yes, Lordship. Page 61.
65.
65, Lordships.
Calculation, last tabular column.
Yes, Lordships.
21 lakhs 81,173.
Yes, Lordships.
You pay 10% of this.
Grateful, Lordships, I'll do.
And we'll direct you to treat this adjudication order as a show cause notice.
Grateful, Lordships.
You give your reply, you submit all documents, he will consider and then read.
Grateful, Lordships. Lordships, that 10% would be the as pre-deposit, Lordships.
No, you deposit 10% of the disputed tax amount alone,
Grateful.
not interest.
Grateful.
This intra-court appeal by the writ petitioner is directed against the order dated 4/8/2025 in WPA 4710 of 2025, by which the learned single bench declined to grant any interim order, but directed affidavit in opposition to be filed by the respondent department. Aggrieved by the same, the appellant has filed the present appeal. Since the issue involved in the writ petition as well as in this appeal lie in a narrow campus, with the consent of the learned advocates appearing on either side, both the writ petition as well as this appeal are heard and disposed of by this common judgment and order. The appellant had challenged an order passed by the appellate authority under section 107 of the WBGST/CGST Act 2017, by which the appeal was dismissed on as time barred. The said appeal was preferred by the appellant, challenging an adjudication order passed under section 73 within bracket 9 of the WBGST Act 2017, dated 9th July 2023. Correct? Adjudication order date.
9th July. Yes,
2023. As could be seen from the adjudication order, despite opportunity being granted, the assessee did not The appellant assessee did not participate in the hearing, nor submitted any reconciliation, nor submitted a reply to the show cause notice. Therefore, the adjudicating authority, namely the Joint Commissioner, cannot be faulted for having passed the order of adjudication. So far as the order passed by the appellate authority is concerned, the same also cannot be faulted since the appeal was filed by the appellant. The statutory appeal was filed by the appellant beyond the condonable period prescribed under the statute. However, considering the fact that the appellant assessee is a running business concern and is genuinely and would submit that reconciliation can be made, reconciliation can be done, and all queries raised by the department can be answered, and they pray for only one more opportunity to enable them to go before the adjudicating authority and put forth all the facts and the relevant material. Thus, considering the peculiar facts and circumstances of the case, we are inclined to grant one opportunity to the appellant to go before the adjudicating authority. However, such opportunity is subject to certain conditions. Full stop. Accordingly, we dispose of the writ petition as well as the appeal by directing the appellant to deposit 10% of the total disputed tax, namely 10% of rupees 21, 81, 173.
Lordships, just a small indulgence, Lordships. While preferring the appeal, we have already deposited 10% as pre-deposit, Lordships.
This deposit of 10% shall be in addition to the deposit which has already been made by the appellant while preferring the statutory appeal. The appellant is directed to comply with the above condition within 15 days from the date of receipt of the server copy of this order, and after producing the deposit challan, the appellant shall treat the order of adjudication dated 9th July 2023 as a show cause notice and submit the reply within 15 days therefrom. Upon receipt of the reply, the adjudicating authority shall fix a date for personal hearing, hear the contentions that may be raised by the appellant, as well as the documents that they may produce, and redo the assessment, redo the adjudication, and pass fresh orders on merits and in accordance with law within a period of 15 days from the date on which the personal hearing is concluded.
Gratefully,
Appeal and writ petition both disposed.
Number 7.
For my I appear for the appellant. Will not led by Mr. Devashish Kundu. Mr. Kundu, no, he tried to appear online. There's some technical glitch. When he's coming, Milord. He will come. But on the last occasion, Milord, we have filed a list of dates, Milord. Since they have, pursuant to my lord's direction, they have already filed a convenience brief for your lordships along with a list of dates. But we felt that, Milord, there are certain events, Milord, which were not mentioned in list of dates, which will be necessary, Milord, for the purpose of consideration, Milord. So we have, Milord, also
in the list of dates.
Yes. Well, this is an appeal arising out of an order, judgment and order, Milord, dated 25th August 2023. Milord, Lordship will get this order at Milord, page 517, Milord, of the stay application, volume 2.
This is in the compilation 102 to 117. Now, please take 102 to 117 of the compilation.
Yes.
Actually, you have seen the order of the trial court. Okay. Oh,
We have just taken the order, page 102 of that small compilation.
531. 517 is fully reached. The 517.
you want to do the, that is the memorandum.
517.
That is the memorandum of opinion.
You can proceed with your set. You can tell us the internal page number.
I will assist you. It's there in the compilation.
We have prepared a list of dates, which may, to a certain extent, vary with the list of dates which has been filed by my lawyer. The lawsuit really take a copy of the list of dates. Maybe 90% of the days may be similar, wording may be different, but I'll tell you, not sure. 2019, the IOC gave a notification that they would be using several plots of land in the local area for the right of user for laying down a pipeline. On that basis, several plots of land were taken over by the IOC through the competent authority, who was also the authorized officer. So, the competent officer has got two roles. One, as a competent authority to deal with and decide the issue of the compensation, and the other is to act as an officer of IOC, take possession of the land in question. So, when he takes the possession of the land in question, that is on March 2000. In the year 2020, 22nd May 2020, he takes possession of 7.08 acres of land belonging to the petitioner for laying down the pipeline, which was for the period of 60 days. So we were given notice that the position would be taken and for 60 days. I'll make the lordships. I will have two fundamental differences with our case and the case made out with regard to the other continuous landowners. In their cases, IOC entered into a written agreement. In our case, there was no agreement. That's a major fundamental difference. So therefore, in those cases, those agreements I have annexed also to show your lordship the difference between the two. In our case, there was no agreement. So, my lord, the competent authority, after taking over possession of the land, he then, at our request, we had prayed for a compensation which he calculated at the rate of 450 per decimal for a period of 60 days. And those amount of 40, which came to 42 lakhs.
Amount of 42 lakhs 12,245.
42 lakhs 12,245. That is, your lordship will find it out at
serial number 4.
Serial number 4.
List of dates.
Of the list of dates, your lordship will see 11, 5, 2004, 21. 42 lakhs. Now those were paid in 2 installments subsequently. Serial number 5. Serial number 3. So in 2 installments, this 42 lakhs and odd were paid to the petitioner.
Yes.
Now, my lord, we were under impression that the land would be taken possession of. They have taken possession of. We were no longer permitted to use the land or utilize the land as well. Because that was within the custody of the competent authority or the authority IOC. And the IOC, having taken possession of the land, for reasons best known to them, they did not proceed with the pipeline for whatever reasons. Naturally, the period of work got elongated. Initial period was for 60 days from 22nd of March 2021, ending on 21st of July 2021. 22nd. And thereafter, my lord, after the expiry of the initial period of 60 days, they were still in possession of the said land. And naturally, my lord, there was no end as to when they would give us possession after laying down the pipeline. It was in a state of flux. So we wrote a letter to them that please calculate the compensation beyond the period of 6 days which are still enjoying. Till the time we actually hand us back the land in question after completion of the pipeline project.
Question is 23. Have a read the considering in the order of passed by the Justice Jeremiah Bhattacharya within key order within key on that is the date we constitute. সেটা হচ্ছে 23 March 2023.
So, my lord, at this point of time, my lord, there was a lot of disputes between the parties as to when they would leave, how long they would take over, because our business was totally not even for a toss. Let's put it this way. So we had no income. Ultimately, we had to file a writ petition for this honorable. Now, in the writ petition, we prayed that please allow us additional compensation for the period over which of 60 days and for which we have not been paid any further sum and they have not even told us the date when they are going to hand over back the position. So, ultimately, by an order of the learned single judge and at the suggestion of my learned friends clients, that number one, the writ petition was not maintainable because there was an alternative remedy available to us, which is Section 10 of the Pipelines Act of 1962. The lordship will kindly come at
page 134. Page 134.
Page 134.
And in the compilation, in their compilation, page 25.
That is page 25 to 29. Compilation.
your lordship is looking at the compilation, then I'll refer to the compilation itself. I don't want to multiply the number of.
If my learned senior friend is referring to 134, that's corresponding to 25 to 29.
No, they are referring to the act.
Act.
No, I'm referring to the order passed by.
The order passed.
Order passed.
Order passed by the earlier honorable.
Earlier.
Earlier. Yeah.
Okay. আমাদের কপিতে 134 ওদের
বার করো না। The lordship will find out that ultimately the writ court or the matter was disposed of by the Nanak trial judge in the earlier writ petition.
Page 134, your order.
Yes, your lordship will kindly come to the related
paragraph 9.
Paragraph 9 only.
Paragraph
9 only.
Page 137.
My management will read the order.
Lord, page 137 is in the.
No, we have got paragraph 9.
Lordship. Admittedly, the pipelines have been laid using a portion of the large chunk of the property. Yes. Admittedly, the pipelines have been laid using a portion of the large chunk of the property of the petitioner. Though the petitioner has a right to use and enjoy the said property as a lessee thereof, he should not be permitted to cause any damage or to undertake any act of activity which is restricted under the provisions of the 1962 Act. In view thereof, this writ petition is disposed of by passing the following orders. The competent authority, being the fourth respondent to the writ petition, is directed to consider the prayer of the petitioner contained in the letter dated February 17, 2022, as expeditiously as possible, but positively within a period of 8 weeks from the date of communication of this order, upon giving an opportunity of hearing to the petitioner or his authorized representative, and to dispose of the same by passing a reasoned order. It is needless to mention that the reasoned order is to be communicated to the petitioner within a period of 1 week from the date of passing of the said order. The petitioner shall be entitled to use the property as specifically mentioned in the Panchnama dated May 22, 2020 in the manner permitted under the provisions of the 1962 Act. There shall be, however, no arrest cost.
Your lordship will see, so the matter goes back to the competent authority. And it was at their request that the court is not the appropriate form. There is an alternative remedy under section 10. Not whether section 10(1) or 10(2), that was it is under section 10. Now your lordship will see, he said that the vital letter which was directed to be considered by the competent authority, that is the letter dated
February 17, 2020.
February 17,
2022.
That letter, your lordship, that is at page, my lord.
Lordship. Page 212 to 215. Page 212.
212 to 215.
112
to 215.
21.
212 to
212 to 215.
This is in page 21 of the compilation.
Yes,
My learned junior will not read the letter first, because this is very vital.
May I place, my lord?
Yes.
This has reference to your notice dated 5/2/2022, whereby I was requested to appear before your good self on Friday, the 11th February 2022 at 12 noon with all relevant documents in connection with my fishery. However, since I received the notice on 3:49 p.m. on the 11th February, it was not possible for me to appear before your good self on the said date. Be that as it may, I have subsequently received your further notice dated 11th February 22 on the 15th February 22, whereby I have been requested to appear before your good self on 17th February 22 at 12 noon in connection with the same matter as contemplated in your earlier notice dated 5th February 22. At the outset, I would like to respectfully state that I have already instituted a writ petition before the Honorable High Court at Calcutta, being WBA number so-and-so, in connection with non-payment of the entire compensation by the Indian Oil Corporation in respect of the loss, damage suffered by me by reason of possession of my leasehold fishery having been taken over by IOCL on the basis of Panchnama dated 22nd May 2020. A copy of the writ petition is annexed. As you are aware that the said writ petition is pending disposal before the Honorable High Court at Calcutta. However, without prejudice to my rights and contentions in the said writ petition, I am now stating the following facts for your kind consideration. The total quantum of leasehold land in respect of my aforesaid fishery, situated in Muja, Mirikpur, jail number 261, Dag number so and others, police station Tumluk in the district of Purva Medinipur is 180 bighas and on 9360 decimals. By Panchnama executed on the 22nd May 20, possession of the said fishery was taken over by the representatives of IOCL in connection with the laying and or renovation work of Holdia Barauni pipeline system project. It is in this connection necessary to mention here that at the time of execution of the Panchnama, the undersigned was informed by the representative of IOCL that the said project will be completed by IOCL within a period of 2 months from the date of execution of Panchnama, and possession of my leasehold land will be made over to me after the said period of 2 months. That acting on such representation of IOCL, I drained out the entire water from the fishery to enable the representatives, contractors, masons, workers of IOCL to carry out their work as aforesaid. However, although a period of 636 days has elapsed since the date of taking over possession of the said land by IOCL, the work in question has not yet been completed. It is pertinent to mention here that till date I have received a sum of rupees 42,12,245 in all from IOCL towards part compensation for taking over possession of my aforesaid leasehold land for the period of 2 months, as is informed orally by the representatives of IOCL at the time of execution of the Panchnama. Inasmuch as a sum of rupees 21,06,122 was paid by IOCL on 3rd March 21, and a sum of rupees 21,06,123 was paid to me on 11th May 21. It is put on record here that although the said part payments were made on 3rd March 21 and 11th May 21, the possession of land in question was taken over by the representatives of IOCL for a period of 2 months only, as informed verbally, with the execution of the Panchnama on 22nd May 2020. It will therefore appear that the first part payment of the said sum of 21,06,122 was made by IOCL after a period of 286 days from the date of taking over possession of the leasehold land on 22/5/2020. It is also pertinent to mention here that by an earlier notification bearing memo number so and so dated 17/10/19, I was informed that my aforesaid land will be taken over by IOCL in connection with the aforesaid project. I was also requested to drain out water from the aforesaid fishery and take possession of the fish lying thereat, and that I shall be compensated for the loss suffered by me by reason of the aforesaid project of IOCL. It is in this connection also necessary to state that in similar circumstance, leasehold land pertaining to Moja Chok Beria in the district of Purva Medinipur has been taken over by IOCL in connection with the aforesaid project. In the said case, an agreement has been executed by and between IOCL and the lessee, wherefrom it appears that the lessee in such identical situation has been compensated by IOCL at the rate of 1,000 per decimal for 110 days from the date of handing over of the fisheries by the leaseholders. It will also appear from the said agreement that since IOCL was not able to conclude the project work within the time as specified, additional compensation has been agreed to be paid, taking into account the additional period for completion of the project. In another instance, IOCL has agreed to pay compensation to the similarly placed lessee for taking over fishery situated at Moja Kalikapur in the district of Purva Medinipur at the rate of 1250 per decimal for 110 days. It is therefore respectfully stated and submitted that IOCL authorities cannot take a divergent stand so far as the undersigned is concerned, more so when they have already paid compensation and or agreed to pay the same to the similarly placed lessees of the area within the same district of Purva Medinipur at the rate of 1,000 per decimal and rupees 1250 per decimal respectively for 110 days each to each of the said lessee. It is respectfully stated and submitted that since the total quantum of land in respect of which possession has been taken over from the undersigned is 9360 decimals, I am entitled to receive a total compensation of rupees 6,76,47,272 calculated at the rate of rupees 1250 per decimal for every 110 days. Since out of the aforesaid amount, a sum of rupees 42,12,245 has already been paid by IOCL towards part payment, I am entitled to a sum of rupees 6,34,35,028 for a period of 636 days, calculated up to 17th February 22, that is today. It is also pertinent to mention here that by reason of non-payment of the entire compensation by IOCL, I have not been able to pay the lease rental to my respective lessors as I am out of business. And since the date of taking over possession of my fishery by IOCL, incidentally, the total annual lease rent which I am required to pay to the lessors is rupees 98,28,000. As a matter of fact, I have been unable to pay the entire annual lease rental for the years 2020 and 2021 till date. It is also necessary.
Yes,
it is also necessary to mention here that after the hearing of the writ petition before the Honorable High Court at Calcutta on 28 January 2022, an anonymous person by the name of one Gajendra visited my house claiming to be from IOCL and threatened me with that unless I withdraw my aforesaid writ petition pending before the Honorable High Court at Calcutta, IOCL
Your Lordship is not keeping very well.
IOCL will institute criminal proceedings against me and ensure that I am sent to jail. I therefore request your good self to kindly take note of the above and take immediate action by directing the concerned authorities of IOCL to immediately make payment of the balance compensation amount of rupees 634,3528 calculated till 17 February 2022 and further make payment of compensation till possession of the said fishery is handed over back to me.
My Lord, this was the letter or representation of the appellant to your Lordship, which was directed to be considered by the writ court, by the competent authority. Now, I will now straightaway take your Lordship to the competent authorities order. That is at page, my Lord.
262, page 262 in volume 2.
Page 262, volume 2, my Lord, which is equivalent to, my Lord, what is the proof, my Lord? Competent authority order. And it's crucial.
Yes. That is at page
Not page 46 to 57.
46 of the compilation. They have
We'll just take your Lordship to the relevant paragraph because it's a very longish order and that too also, my Lord, is not typewritten, my Lord.
এখান থেকে ইমেল থেকে শুরু করি একটুকুন পড়ে দিই। My Lord, may I place from the last slide of the first page of the order from it is also necessary to state, which is very much relevant, that by an email dated 25/1/22 sent by Mr. A.J. Chakraborty, General Manager IOCL, Holdia, regarding manhandling of the fishery owner and the proceeding was initiated by the undersigned by issuing by issuing the notices to the petitioner and also IOCL personnel, requesting to appear before the undersigned with relevant documents. On this page number 263,
Page 47 of the compilation.
corresponding 47
46 last sentence.
46. The second page 263. Yes, 263 without each page.
That is for the IOCL to say, my Lord, not for. He should, my Lord, give them a copy, my Lord.
এখান থেকে 266 but I was placing for page 266 in if I may, and this will correspond to I'll just give the page number. No, Lordship. No, I was placing page 266 of the paper book, and the compilation is page 50. Page 50, 50. What for the second paragraph I was placing? Lordship.
May I just sit before?
But I was placing the second paragraph. Lord. In the instant case, a sum of rupees 42,12,245 has been paid by IOCL to the petitioner without executing any agreement thereto. Lordship has got that. Therefore, the contention of the petitioner is correct to the extent that there is no agreement with regard to the quantum of compensation, the rate of compensation, and the period for which the compensation will be paid. In absence of execution of the said agreement, on the part of IOCL, the contention of the petitioner cannot be brushed aside that IOCL made payment on account compensation to the petitioner. On the contrary, it has been submitted by IOCL that the acquaintance roll with regard to the new project was prepared and crop compensation for the period from 1/3/21 to 28/2/22, totaling rupees 42,12,245 was paid to the petitioners partly on 3/3/21 and partly on 11/5/21. On perusal of the said acquaintance roll, the said period of time, that is 1/3/21 to 28/2/22, does not come to my notice. IOCL has also stated that the ROU corridor within the fishery of the petitioner was scheduled to be handed over on 28th February 22 under the normal circumstances. However, due to the constant hindrance caused by the petitioner, the completion of the project work got delayed. It is also stated by IOCL that they have completed all activity in the village Mirikpur in February 22 and that no objection certificates from the plot owners, leaseholders, fishing owners were obtained by IOCL. On verification of these certificates, it appears that all are dated in the months of June, July 22. It is not clearly understood the reason for the gap of nearly 4 months in issuing those certificates by IOCL. It is worthy to mention here that in all the cases, initial agreements were executed by and between IOCL and the respective owners, with regard to the payment of compensation, and the said compensation was ultimately paid on the basis of such agreements. The undersigned, as the competent authority, was never consulted primarily on a part of such discussion on the part of IOCL and the leaseholders. In majority of the cases, where the subsequent disputes and IOCL could not settle up with the respective leaseholders, the undersigned is asked to interfere in it. This instant case is one of such case where there was no discussion with the undersigned during the payment of the sum of rupees 42,12,245 by way of crop compensation, excepting that two checks for the respective sum of rupees 21,06,122 and 21,06,123, which were signed by the undersigned against the award prepared based on Panchnama for payment of two leaseholders by way of compensation. The undersigned was never discussed prior to negotiation or settlement with the leaseholder. It will appear from the copy of the email dated 25th January 22 sent by the General Manager IOCL Holdia, Construction Division, addressed to the competent authority that the job or project work has been stopped due to site persons of IOCL having been manhandled by the fishery owner by the aforesaid mail. It has been requested that out of court settlement is to be tried for the sake of starting the job. Settlement in this case has a direct or indirect hint of additional compensation or further compensation to the leaseholder. Taking into account the total compensation of 42,12,245 for the total affected area of 9360 decimal of land, the rate per decimal comes to rupees 450 per decimal nearly. The contention of IOCL is that the project work completed within the period commencing from 2nd March 21 to 15th May 21, that is within a period of 2 months. Although it has been contended by IOCL that the petitioner had handed over only the land within ROU area and not the entire quantum of 9360 decimals, cannot be accepted in view of the fact that the Panchnama dated 22/5/20 records that the total area of affected crops is 9360 decimal, which corroborates with the affected area of 3,78,799 square meter or 93 decimals as mentioned in the acquaintance roll. In the email dated 25/1/22, written by the General Manager Construction, IOCL Holdia, there is no mention that the petitioner was carrying on pisciculture on the aforesaid leasehold land, although in respect of other leaseholders mentioned in the same mail, it appears that the said general manager has specifically mentioned that the cases where the respective leaseholders were carrying on pisciculture in their respective leasehold land. Again, on a perusal of the police complaint dated 9/2/22 made by the said General Manager Construction Holdia to the Tomluk police station, it appears that the fishery was dried up by the petitioner after making necessary compensation and the work started. There is no whisper in the said complaint made on 9th February 22 that the petitioner was carrying on pisciculture in his leasehold land. The photographs of the fishery as taken during the drone survey by IOCL on 5/12/21 as stated in the written statement of IOCL. The question of the petitioner was carrying on pisciculture in his leasehold land also cannot be accepted in view of the grounds stated above. The white dots which are visible in the photographs produced cannot establish that the petitioner was carrying on pisciculture in the said fishery. The learned lawyers for the petitioner denied regarding such pisciculture also. The petitioner by his representation dated 17th February 22 prayed for compensation at the rate of rupees 1250 per decimal for every 110 days. On a perusal of the said agreements annexed to the writ petition, it appears that IOCL has paid rupees 1000 per decimal for 110 days. In the instant case, the petitioner has accepted the rate of rupees 450 per decimal without any objection. Hence, the rate per decimal cannot be enhanced. The petitioner on several occasions during hearing and in his letter dated 17/2/22 stated that he has been verbally told that the project will be completed by IOCL within a period of 2 months from the date of execution of the Panchnama. It has also been stated in the affidavit submitted by IOCL that before the Honorable High Court that it is rather impractical to state that the plots were taken over only for the period of 2 months for buying of pipes. By an email dated 25/1/22, the matter was referred to the undersigned by the GM Construction IOCL Holdia for out-of-court settlement. Consequent upon receiving the said mail and the present proceeding was initiated, which was ultimately kept in abeyance in pursuance of the pendency of the writ petition filed before the Honorable High Court at Calcutta. However, since having regard to the subsequent judgment dated 23rd March 23 passed by the Honorable High Court, the undersigned is considering the representation dated 17th February 22 made by the petitioner before the undersigned. Therefore, it cannot be contended by IOCL that the undersigned has become functus officio and cannot decide the question of payment of additional compensation or further compensation to the petitioner. Regarding embankment of IOCL admitted that they have not constructed the said embankment, and as such the petitioner has the liberty to take his decision with due adherence to the existing rules and laws. I being empowered under section 2 of the Petroleum and Mineral Pipeline Act 1962 and upon direction of the Honorable High Court at Calcutta do hereby pass the following award. The order as follows. The petitioner is entitled to further compensation at the rate of rupees 450 per decimal for 60 days for the period from 20th May 2020 to 13th June 22, that is the 754 days. Since the petitioner could not cultivate the leasehold land from 14th June 22 till the date of handing over the possession on 23/3/23, he is entitled to get presumptive crop value in terms of Rule 4(2)(e) of the PNMP rules 1963, that is for 283 days, which will be 80% of the crop value. The award is to be prepared and
Your Lordship sees, my lord, that the
IOCL was that officer has become functus, so he can't act. That he has decided in your favor, that he has got jurisdiction to do. The competent authority also comes to the conclusion that the work was not completed within 60 days, you are entitled to. But so far as your claim of 1,250 per decimal, he says that you have accepted 450. Therefore, I will give it only at 450 plus etc. The decretal portion of the order is at the last paragraph. 450 per decimal for 60 days from 20th May 2020 to 13th June 2020. Now, this order was challenged by IOCL
in the instant writ petition against which order, Lord, we have preferred an appeal.
All right. Now, straight away, can you go to the finding
Yes,
rendered by Justice Sabishashi Bhattacharya? It starts in the compilation is page 102. Paragraph 17 onwards will be relevant.
I'll please.
Ditesh, that act is there. That act called
May I please?
Petroleum and Minerals Pipeline Acquisition Act. Yes.
Paragraph 17 onwards, may I please?
Paragraph 17.
Hard learned counsel for the parties. Section 10 of the 1962 Act is set out below. As Lordship has set out below Section 10. I am not placing that. Then kindly skips over one page, the next page. Then paragraph 18 onwards.
Yes.
Subsection 1 thereof is clear on the issue that the CA is the authority to determine the amount of compensation in the first instance. Subsection 2 of Section 10 only comes in where the compensation determined by the CA under subsection 1 is not acceptable to either of the parties when an application is to be made by the aggrieved party to the district judge having territorial jurisdiction to be determined by the district judge. Thus, the compartmentalization of the first authority and the appellate authority is clear and unambiguous in the statute. The reliance of the respondents on subsection 3 to portray that the said provision confers co-equal powers on the competent authority and the district judge is rather misplaced. It is clearly stipulated in subsection 3 that the CA or the district judge, while determining the compensation under subsection 1 or subsection 2, as the case may be, thus the powers are not co-equal between the two authorities, but to be exercised by the CA or the district judge under subsection 1 or subsection 2 respectively. The expression used to distinguish the two is as the case may be. Subsection 3 is less on competence and the power of the authorities and more on the modality of assessing damage or loss. The yardsticks for so assessing have been stipulated in subsection 3 as the removal of trees or standing crops, temporarily severance of land and other injury to property on the earnings of the person concerned, etc. In fact, subsection 5 of section 10 further reiterates that the market value of the land on the relevant date shall be determined by the CA, and if the value was determined by that authority is not acceptable to either of the parties, it shall, on application by either of the parties to the district judge, referred to in subsection 2, be determined by the district judge. The section continues to stipulate in subsection 6 that the decision of the district judge under subsection 2 of subsection 5 shall be final. Thus, a terminus is given to the proceeding once the matter is decided by the appellate authority, that is the district judge, which is obviously absent in the case of CA, which is but the authority in the first instance. Thus, the clear delineation of authorities between the CA and the district judge does not come under the scanner, even on a plain reading of the relevant provisions of law. The next question which arises is the alleged submission of IOCL to the jurisdiction of CA. However, a clue in that regard has been given in the impugned order of the CA itself. In the said order, it is recorded that by an email dated 25/1/22, the matter was referred to the CA by the GM Construction IOCL Holdia for out-of-court settlement. The CA further continues that consequent upon receiving the mail, the proceeding in question was initiated, which was ultimately kept in abeyance in pursuance of the pendency of the previous writ petition before this court. The CA observes, however, having regard to the subsequent judgment dated 23/3/23 passed by this court, the CA is considering the representation dated 17/2/22 made by the petitioner before the CA, and that therefore it cannot be contended by IOCL that the CA has become functus officio and cannot decide the question of payment of additional compensation or further compensation to the petitioner. The CA further derived his perceived power from Section 2 of 1962 Act, apart from the direction of the coordinate bench of this court. In such context, we are to scrutinize the relevant observations in the order of the coordinate bench. The said judgment was an order was delivered on March 23, 23 in WPA number so and so between the private respondent and the present petitioners. It was observed in the paragraph 3 that in course of hearing, learned senior counsel appearing for the present respondents drew attention of the court to the letter dated February 17, 22, which was addressed to the CA, and it was submitted that the issue regarding payment of compensation in terms of the 1962 Act was pending for compensation for consideration before the CA, and this court, instead of entering into the merits and of the claims and counterclaims of the parties, may direct the CA to decide the prayer for payment of compensation contained in the letter dated February 17, 2022. Learned senior counsel appearing for IOCL did not oppose the prayer to the effect that a direction may be passed upon the CA for deciding the prayer for payment of compensation to the petitioner under the provisions of the 1962 Act. In such context, the court observed that the payment of a sum of rupees 42,12,244 to the present private respondent on account of compensation was not in dispute, but the present grievance of the petitioners is with regard to the enhancement of compensation and payment of any further sums in terms of the provisions of the 1962 Act. Accordingly, the writ petition was disposed of by directing the CA to consider the prayer of the petitioner therein, present respondent number 2, contained in the letter dated February 17, 22, within the time as stipulated therein. A careful perusal of the order of the said order shows that the direction of the court was passed on a subtly different footing than the concession given by IOCL. Learned counsel appearing for the IOCL had not opposed the prayer of the petitioner that a direction be passed upon the CA deciding the prayer for payment of compensation to the petitioner under the provisions of the 1962 Act. The said submission was not a clear-cut and unambiguous submission to the authority of CA to re-adjudicate the issue on compensation afresh on merits. The decision on the prayer of the payment of compensation of the petitioner under the provisions of the 1962 Act implicitly contemplates an element of adherence to the 1962 Act as well as an adjudication on the prayer of the private respondent herein. Section 10 is a part of the 1962 Act and delineates the respective jurisdictions of the first authority and the appellate authority. Again, a direction to arrive at a decision on the prayer of the present respondent number 2 did not mean that such prayer had to be necessarily allowed. A decision may also include adjudication on the question of authority and jurisdiction. As such, it cannot be said that there was an unqualified submission of the IOCL to the jurisdiction of CA to re-adjudicate and the compensation granted to the private respondent. Thus, distinguishing the consent from the ordering portion, we find that the direction of the learned single judge was for the CA to consider the prayer of the petitioner contained in the order in the dated February 17, 22. A consideration of the prayer did not necessarily mean that the CA has to allow it. Such a direction for consideration also includes the option to reject, including a rejection on the ground of jurisdiction as well. Thus, in the first place, neither the submission of the IOCL nor the direction of the coordinate bench conferred any jurisdiction on the CA, which it does not otherwise have in law. Hence, the adjudication of the prayer of the private respondent herein, as embodied in its letter dated February 17, 22, could very well have culminated in the rejection of the ground of jurisdiction alone. Another aspect of the matter is that the proceeding before the CA had not been initiated either on the direction of the coordinate bench or on the letter dated February 17, 22 of the respondent number 2, but on an email dated January 25, 2022 of the IOCL specifically for out-of-court settlement. Although there is some doubt as to whether even such exercise can be entered into by the CA, such doubt may also be applicable to the appellate authority and as such was rightly taken up by the CA to avoid unnecessary relegation of the parties from pillar to post. However, as the said email said, the said consideration was confined essentially to an out-of-court settlement, which by definition is an agreed resolution between the parties. The moment such resolution failed and there was no consensus ad item, the CA ought to have refused to interfere and delegate the aggrieved party to an appeal before the district judge instead of assuming authority which it does not have in law. Thus, the assumption of jurisdiction by the CA is patently dehodes the law and cannot be given a sanction by a court of law. The Act of 62 does not confer any power of review or re-adjudication by the CA. In the present case, the Panchnama executed in favor of the respondent number 2 for the purpose of awarding compensation in the first place to the respondent number 2 has been annexed to the writ petition and considered by the CA as well as in the impugned order. The CA in his order refers to him not being consulted. However, the complete sentence of the CA shows that the said consultation was with regard to agreements entered into between IOCL and the third parties who, according to the respondent number 2, were similarly placed and had got more compensation. The same was a component of the challenge of the respondent number 2 before the CA afresh, and after the compensation was awarded to him in the first place. In fact, there is no dispute that CA was a party to the Panchnama which granted compensation in the first instance to the respondent number 2 within the contemplation of section 10(1) of the 62 Act. Hence, as clarified in subsections 2, 3, and 5 of section 10 of the 62 Act, the scope of challenge by a party to whom the adjudication is not acceptable is only before the district judge having territorial jurisdiction and not before the CA afresh. Hence, the judgment of the present petitioners regarding lack of jurisdiction, the argument of the present petitioner regarding lack of jurisdiction of the CA is justified. It has to be added here that the argument regarding IOCL having acquiesced to the jurisdiction of CA cannot be accepted also because it took objection as to the authority of the CA, which was argued to have become defunct or functus officio before the CA himself. The impugned order of the CA records such argument. Such objection at the outset of the adjudication by the CA, read in conjunction with the interpretations of the submissions of IOCL before the coordinate bench and the direction given by the said bench, unerringly indicates that IOCL never accepted the authority of CA to decide the question of adjudication afresh on merits. Hence, in view of the above discussions, WPS so is allowed on contest, thereby setting aside the impugned order passed by the competent authority, respondent number 1, dated May 2022, whereby the compensation to be awarded to the respondent number 2 was decided afresh by the respondent number 1. However, in view of the pendency of the litigation for so long, it is deemed that the respondent number 2 is not yet out of time for preferring a challenge against the compensation awarded in the first instance before the concerned district judge, having territorial jurisdiction to decide a challenge under section 10(2) of the 62 Act.
So basically, some of the issues which will require is whether your claim is for additional compensation or for enhanced compensation. No, we'll just call out the points.
Oh, good.
If it's a case of additional compensation, it would necessarily mean, it should mean that there has not been a prior determination. Because subsection 1 says, in the first instance,
that is very important,
shall be determined by the competent authority in the first instance. According to the petitioner, in the second representation which was given on 11th of April 2023, a claim was made at the rate of 1250 per decimal. You have cited 2 references in the same district, one where they paid 1,000 rupees and one they were paid 1,250. You have also indicated that in those 2 cases, IOCL entered into an agreement and it's a fallout of that agreement. But in your case, it is only a Panchanama. So, if it is a case of additional compensation or a claim for compensation, it is a fresh claim. If it is a fresh claim, your case is it should fall under 10(1). In your representation, you want an escalation of from 450 to 1,250. If that escalation you want even for the back period, which was paid, that is from 22nd of May 2020 to 21st of July 2020, 60 days, to that extent, already determination has been taken place enhancement under subsection 2. But the other issue which they'll have to answer is, in the absence of an agreement between the parties, can you be compelled to pay accept 450? They have to answer. Second, Visrupa has to answer. After the order passed in the earlier writ petition in WPA 198/95 of 2021, are they entitled to question the jurisdiction of the competent authority to decide your representation dated 17th of February? The learned judge says, but at that point of time, IOCL did not raise this objection. It would have been well open to them to raise. So we will continue. But one thing, no prejudicement, your action is highly arbitrary, to say the least.
I'll tell you one further thing.
In my career of practice, I've appeared umpteen number of matters against oil companies. 90% have succeeded. And after becoming a judge, both the single bench as well as the division bench, so many matters, including reclaiming possession of the land. Have you seen those agreements you enter into for the petrol pumps? Petrol pumps.
Petrol pumps, yes.
For life, you cannot get the land back. And what they will pay, 1,200 rupees per square feet or 500 or 700 rupees per square feet. You think petrol pump owners are big landlords? Nothing. They are slaves of your oil companies. And I will give the name of one senior advocate. His grandfather was such an illustrious person in the country, fought for freedom struggle. At that time, public sector benevolence, he gave the land. That outlet did not function, yet IOCL did not surrender. The grandson, after coming into the profession, started litigation. Now the grandson is close to 70 years, designated senior. 2 years back, they got possession of the land. Highly arbitrary. On technicalities, we will decide. But prima facie, that is why at some point of time.
Well, this is no question of possession. This is right of user.
No. Right of user, we know, sir. We know what is the right of user.
No, they are enjoying. They are running PC culture for them.
You go and see how they will enjoy. Huh? You can't you can't plant a tree. You can't do anything.
With greatest of respect, I will not argue now. Your Lordship is keeping it tomorrow. Today.
Monday.
The same position, so that we can finish the matter.
And how did they fix 450?
There is another very story behind that. I'll invite the lordships to that part also, because there was nothing.
Let him not say something which is beyond the records and pleadings.
No.
I should not be
You, when your turn comes, you can oppose tooth and nail.
No, not tooth and nail. 450 was accepted by them.
No problem. The thing is, that is why some sensible fellow in the oil company thought fit to make an out-of-court settlement. That fellow had some reasonableness in his mind and his heart.
The general manager.
In his mind and his heart. Heartless fellows filed the writ petition. And right of user, he says 9,80,000 rupees he has to pay to the lessees because they have been ousted.
Lakhs rupees.
Huh?
1,000 rupees. 98 lakhs.
98 lakhs. Because water had to be drained out, land had to be dried for you to lay the pipeline.
You kindly do not go by whatever he is saying to be correct. It is not sacrosanct.
See, unless.
Yes, your lordship's reaction will enable us to come full proof.
Yes. So these are at least 4 or 5 questions to be
Yes, I've understood.
That's it.
Live streaming.
Even now it is not too late. Even now it is not too late. If you are willing to accept, that is subject to what Mr. Kundu's client will say. You accept the order of the competent authority. We will say that we will affirm Justice Abhishek Bhattacharya's observation that he did not have jurisdiction, we'll affirm. They are not entitled. The judgment they are not going to frame and put it in their house. What is the use? Client will not appreciate that. What he wants is you accept it, but on law, we will agree with you. We'll affirm this. And we will give him liberty to question for enhancement from 450 to 1250 by approaching subsection 2 in terms of para observation. Subject to what they see, ultimately, no, you have to pay. You have to pay in the sense you have to pay for the period for which the land.
The 286 days.
Whatever it is. So we will calculate it at 450 for the present.
That 450 part, he has also not challenged it. 450 has been upheld by the competent authority also.
No. Subsequently, they
With
gave
respect,
they gave
450 was sought for 1250. 1250 was not declined, was not accepted.
How did you enter upon the land? It is clearly in violation of the procedure under the Act.
Perhaps we have an answer there. It is not.
So, in his representation on 11th of April 2023,
my lord,
they have asked for 1250.
That was not accepted by the competent authority.
1250 from what date? If they want it from 22nd May 2020, then they have to go under subsection 2. So you discuss with your client and they will also discuss 450 plus whatever is the competent authority has granted, you pay. We give him liberty to approach under subsection 2 before the district judge. That will be a very reasonable approach. Very reasonable approach.
And without prejudice, would your lordship be pleased to record so that we can, come back, if it comments to
their client, I don't know whether they'll be.
But without prejudice to all rights,
what we can say is we have
kindly make this observation if it comments.
May I make this submission? Insofar as my clients are concerned, I can vouch before your lordships that the sum of rupees 450 per decimal, which was calculated by the competent authority for the first initial 60 days, and thereafter he recorded in his order. Since my clients had already accepted 450 per decimal, there is no chance of enhancement of the same.
Correct. Enhancement, you go before the district judge.
So your lordship, kindly record this thing. My clients are ready and willing to take the further compensation for the period for which it was not paid by the IOC, and the rate will be 450. Yes. And the rate will be 450 per decimal.
With liberty to challenge.
Yes, of course.
Sir, come to page 57 of your compilation. The petitioner is entitled to further compensation at 450 per decimal for 60 days for the period 20th May 2020 to 13th June 2022, that is for 754 days. Since the petitioner could not cultivate his leasehold land from 14 June 2022 till the date of handing over possession on 23/3/2020, he is entitled to get presumptive crop value in terms of rule 4(2) so and so, that is for 283 days, which will be 80% of the crop value. The award to be prepared prior to the bonus, etc. You comply with this. You comply with this. On legal issue, we will say all is well. We can do one thing. We will leave this legal issue open. Like Honorable Supreme Court, when it sends back the matter or says that, we dismiss the SLP. However, we leave the legal issue open.
I have understood, perhaps, I have tried to follow what is passing through your lordship's mind. Your lordship will keep it.
No. You are a public sector. No, you are a public sector. It's literally hitting them below the belt.
No.
Obviously.
He was gunning
Then we'll do one thing. We pass an intermodern now. By Monday, you deposit this money with the Registrar General.
Kindly do not say this. Kindly do not say this. Kindly keep the question open. We'll come back on Monday.
Please call them. See, public sector people, they need to be advised properly. Who takes a decision is very, very important. But there was a reasonable man in the oil company, which prompted him to make a proposal for out-of-court settlement. You have utilized his land, sir. And in the earlier
This part is perhaps, my lord, a little, my lord, has to be explained. My lord, kindly, my lord, my
used in the
documents here evince, my lord, that he was using it very much for pisciculture, and there were pictures, there were, my lord, every document produced
that
before.
you cannot raise now.
No, we raised it before the CA. We raised it before the CA without prejudice to an argument that the CA has no jurisdiction. We also raised these issues.
All right, leave alone everything. You could not complete the work within 60 days. No agreement. So therefore, we will determine the compensation at market rate along with solatium and interest in terms of the latest 2013 Act. It's a welfare legislation, sir. This is an archaic legislation of 1962. What is the Right to Fair Compensation Act? We will say we will say that provisions of Right to Fair Compensation Act has to be read into the statute. We are in the year 2025. We are not
again something, Milord, perhaps, Milord, kindly do not, Milord.
No. We are not under colonial rule. You may be a public sector, but we are not your servants.
Who?
Therefore.
No.
Land was handed over. Land was not handed over after 60 days. And the land was handed over.
You call this fellows an
Your Lordship will
450 plus this crop compensation at so and so rate in terms of the rules. You pay it. If they want to take it happy, let them take it. If they don't like it, let them go to district judge. All points open.
Milord, would it be your Lordship's gracious pleasure to keep it, Milord, on Wednesday instead? Milord, we will not be getting the officers, Milord.
No, you will definitely get it.
How?
Tomorrow is a Friday.
To a Friday, you want me to work?
So are you encouraging?
Monday. No.
Monday.
Otherwise, the thought process.
Tuesday.
Monday.
Very well, Monday.
We have extensively heard the arguments of Mr. Kundul and a senior advocate for the appellant. For continuation of arguments, list on so and so, higher on board. Let us see, because Mr. Biswarup Bhattacharjee is a very benevolent person.
Huh?
He is a very benevolent person.
But benevolence will not in this.
No, I am telling you as a person. When we are hearing a PIL, he immediately stood up and said, I am sponsoring.
Oh, that is neither here nor there. Please. Kindly do not import that.
So therefore, you need to advise clients. And especially, and what is the policy of the government of India? Policy is zero litigation. And who's the biggest litigant in the country? It's the government.
Union of India.
It's the union. It's the government. Something you do. Let them keep the land fallow. Let them not do pisciculture. Let them not do grow crops, etc.
Yesterday I was appealing a matter in which was given to me by the Union of India. Union of India is the petitioner against the state of West Bengal. 1997 matter pending till date. And the Union of India hands me over the copies without the original issue being a part of it. I have to pray before the single judge that give me a certified copy of the petition, so that I have the entire.
That will be very reasonable, sir. That will be very reasonable. In all thing is 90%, he may not even go before the district judge.
Kindly, Milord, let us come back fresh on our minds.
Under the National Highways Act, I have decided one batch of cases.
Huh? National Highways.
National Highways Act.
Yes, acquisition.
I distinguish a couple of decisions, etc. Matters now on appeal in the Supreme Court. However, one coordinate division bench did not accept my view. They took a different stand. See, under the provisions of the National Highways Act, the procedure to be adopted is on
Section 10 proceedings. 10 proceedings. Yes. 10A, 10B.
So, what will be the scope of challenge under 34? If Possibly, if you find time, you read the judgment.
Your Lordship judgment, recently the Supreme Court has referred the matter regarding MSME Act to the larger bench. Very interesting. I cited a judgment before a coordinate bench, here, not coordinate bench, as an honorable single judge, on the question of alternative remedy. There was a pronouncement not reported in 25 volume 4 SCC page 1. Now there I find, on going scrupulously going through the judgment, it appears that 25 volume 4 SCC 1 has referred a latter judgment reported in 25 volume 5 to the larger bench on the question of this, what exactly is.
And moreover, what needs you, what they say is, you need to look at it on a different prism. This is a right of, what you exercise, a right of compulsory acquisition.
But this is not acquisition here. Oh, yes, there, right, correct.
Give some credence, sir. I've done matters on this. I've done matters under Telegraph
Sorry,
Act,
which one?
No. So,
No more.
Under National Highways Act, West Bengal State Highways Act, all enactments, they are all compulsory acquisition. So your defense itself was in these type of statute where Electricity Act, when they place the poles, Telegraph Act, this Pipeline Act, then there is another act, I don't know, that is also for the Gas Authority of India, GAIL.
GAIL.
There is another enactment for that also. There is another. So these are all enactments, some of which are you exercise the power of eminent domain or right of compulsory acquisition. After the 2013 Act, the entire way you approach has changed. You see the enactment, it is not compulsory. Land Acquisition Act 1894. That was colonial mindset. Now, right to fair compensation, etc., Resettlement and Rehabilitation Act. The title of the enactment shows what is the mindset. You have to have a change of mindset. So once you exercise the power of eminent domain, in my observation in the Madras High Court Division Bench, I said that
find out.
You have to bear in mind the object of the enactment